what's the difference between fraud and fraudulent transfer? The definition of fraud is wrongful or criminal deception intended to result in financial or personal gain. We define fraudulent transfer, however, as an effort to avoid debt by transferring assets to another person or company. So what is a fraudulent transfer? Fraudulent transfer of assets occurs when a person makes a transfer of assets with the explicit intent to delay or defraud creditors. Fraudulent transfer of assets is often called fraudulent conveyance. The law governing fraudulent transfer of assets in the United States is under the Uniform Fraudulent Transfers Act, or UFTA. Now, there are two types of fraudulent transfer. There is actual and constructive fraud. A transfer made to an asset protection structure in order to render a debtor insolvent constitutes actual fraud. How to avoid fraudulent transfers? First, pay attention to timing. Timing is a very critical component to avoiding claims of fraudulent transfer. Number two, avoid insolvency. Another major component which affects fraudulent transfer claims is whether or not the debtor is solvent. If a transfer of assets renders a debtor insolvent for the purpose of satisfying a creditor's claim, it is possible that the transfer will be deemed fraudulent. It is advisable that individuals avoid making transfers which could make them unable to repay their debts. Number three, keep intentions above board. Number four, consult a professional. Asset protection planning frequently involves the use of complex structures which require knowledge of the laws in multiple jurisdictions.